and welcome to the webinar series, How to Manage a Construction Project. On behalf of myself, Leah Chrisman, AVP, Linda Chrisman, owner of the Mid-Atlantic Real Estate Journal, and Ronald Shapiro, producer of today's event, we would like to thank you all for joining us this morning. As you may know, the Mid-Atlantic Real Estate Journal is a commercial real estate trade, print, and digital publication. We have a readership of over 25,000 industry professionals throughout the Mid-Atlantic region. If you find this program interesting and would like to get your company involved in future webinars, please reach out to myself or Ron. I would like to thank our sponsors for today's event. Without their generous support, this conference would not be possible. Thank you to Saiber, Attorneys at Law, and Partner Engineering and Science. Ronald Shapiro is our moderator for today's program. Ron is a retired assistant professor at Professional Practice, Finance, Economics Department at Rutgers Business School. He taught real estate finance, investments, and financial management courses on the Newark and New Brunswick campuses. If you have any questions throughout the webinar, please send them directly to Ron. Please welcome Ron and his amazing expert speakers.
Thank you, Leah. Good morning, everybody. This morning, we are pleased to present Bob Barone, Director of Construction Services at Partner Engineering and Science, along with Justin Calta, Robert Nussbaum, and Randi, Schillinger, partners at the Saiber law firm. They will present collectively how to manage a construction project. The bios and email addresses for all our speakers are included in today's PowerPoint presentation, along with information on both organizations. I would also like to thank all the speakers and both organizations for their participation in today's webinar. We encourage questions from the audience. Please submit them using the Q&A or chat tabs on the bottom of your screen. We'll try to get to as many questions as time permits. And with that, we have a lot of information to present to you. Let's get started. Our first speaker will be Randi Schillinger. Randi.
I'm just going to introduce the speakers for Saiber. Justin Calta is going to talk about an overview of zoning in New Jersey. I'm going to talk about financing the construction project, and Rob is going to talk about all the construction contracts, construction liens, alternative dispute resolution, and retainage. And from there, we're going to go into Robert Barone, who's going to talk about, I'm going to leave it for him, but from the engineering side for construction. We did it this way, feeling that this is how the construction project runs, and we wanted to present it in the same light. Justin?
Good morning, everyone. Justin Calta. I'm a real estate attorney at Saiber. A large part of my practice involves land use and zoning. Like Randi mentioned, land use and zoning is a pre-permit process. It's the approvals that you need in order to be able to get the permit to build your project. So, briefly, I think zoning reminds me of an old statement about chess, that it's a body of water where a mouse can drink or an elephant can bathe. It covers everything from the gazebo or the pool you want to put up in your backyard to high-rise buildings in Hoboken or Jersey City. The primary statute in New Jersey that governs land use and development is the Municipal Land Use Law. There's another related statute, the Local Redevelopment and Housing Law. That statute permits private developers, among other things, to work with the municipality to clean up blighted areas, come up with a redevelopment plan, which is essentially the zoning regulations that would govern your building project. The primary difference between the two statutes is that the LRHL permits you to receive certain financial incentives, such as tax abatement period or payment in lieu of taxes program that are pretty salient in New Jersey. So generally, the municipal land use law establishes more or less a floor. There's certain procedures that bare bones skeletal framework that it delineates, but a good portion of the development process is really delegated to municipalities. And the zoning power is generally divided between two primary boards, the zoning board and the planning board. And the way zoning is carried out in a municipality, it's you really look to the zoning ordinance, and the two primary criteria in the zoning ordinance are permitted uses, what you can do, what you can build, in a given zone, and the bulk criteria, which is an industry term that essentially means the physical characteristics of what is permitted with a construction project. Now, obviously, in New Jersey, not all lots or properties neatly fit this utopian ideal that municipalities have drafted into their ordinances. So when you need relief from any of those criteria, that's called a variance. Two general categories of variances. Use variances, that's a D variance. It also pertains to structures. Think about, I want to put up a McDonald's in a suburban residential area. You'd need a D variance for something like that. C variances have to do with the bulk criteria. I want to go a little higher, a little closer to the street or my neighbor's property line than what I need, or what's permitted rather. Zoning boards have exclusive jurisdiction over D variances, and that includes applications that would otherwise be before a planning board, right? So if you need site plan approval with the D variance, you're in front of the zoning board. Planning boards have power to approve subdivisions and site plans. And if you have an application for development that involves something that does not meet the site plan criteria, most municipalities exempt single or two-family homes from that process. You're back in front of the zoning board. So, today's theme is how to manage a construction project. I'm sort of covering the topic about what happens before the permitting process occurs. And a big part of that is development contingencies. What happens if you've identified a project or a property that you like that you think is suitable for your project, and you want to proceed with purchasing it. You should have a good development contingency, meaning that you do not have to purchase the property until you've obtained your approvals. There are two rules that we like everybody to abide by when they're purchasing property. Rule 1, do buy what you will build, and rule 2 is do not buy what you will not build. They're pretty clear, straightforward, but a lot of people sort of lose sight of them sometimes. You should be clear early on that closing is contingent on obtaining all your necessary approvals, and that means in the first discussion you have with the seller or in the LOI, you should be specific about the project you want. If you're not going to purchase, if you can't build, for example, at least 10 units, you should define with specificity that you want at least 10 units. You should also describe what you do not want. There's usually a general phrase in a approval contingency paragraph, that if you get bogged down with conditions or, the board makes it so that your project is no longer feasible for your budget and what you have in mind, that you can back out. You should be general about what approval means, right? Municipalities aren't the only agencies that have their hand in the approval pot. There's the DEP for wetlands or other, environmental matters. You should be broad because, the worst case scenario is, you've satisfied one contingency, you've got some approvals, but you're obligated to close, but you don't have everything you need in order to build yet. You should also give yourself adequate time to obtain the approval. You're moving at the speed of government during the approvals process. If you're putting up a single family home, maybe you can do it in a couple months, a year. If you're doing a larger, multi-unit ground floor retail project, 18 months, something like that, with the option to extend the process. Also give yourself an outside date, right? So if you don't have it within 2 years or something like that, you can walk. You don't want to be locked into a contract forever. Sellers are generally amenable to this too, because they don't want their properties off the market indefinitely. So let's say you have your approval. Everything's good to go. You're ready to pull your permit, right? Wrong. You have to go through the resolution compliance process. Resolutions of approval are going to contain conditions. These are the items you'll need to satisfy before you can pull your permits. Conditions range from the garden variety, such as, you need to pay fees and escrows, to the specific. You went in with a request for a building coverage variance. The board asked you to shrink the house a little bit, and you agreed to do it. Resolution compliance can be a significant delay that no one anticipated. Disputes range from did I agree to that to the scope of it. Yes, I agreed to provide additional parking, but you want pervious concrete for that, for the parking area, and that's more expensive than what you otherwise had anticipated. You should also be careful about what conditions you will agree to and won't. Right, you're going to feel a lot of pressure during a board hearing to say yes to a lot of things in order to get your approval. Just remember the 2 rules. Do not buy what you will not build. And, if everything goes well, I think I'd leave you with this. Zoning is both an art and a science, and sometimes it's more art than science. But, if you have a good attorney, you can get through this process with the project that you need. And, when it's time to pull the permit, you're going to need financing. And for that, we're going to turn you over to Randi Schillinger.
Hi, my name is Randi Schillinger. I am a real estate and environmental attorney with Saiber, and I have done probably for the past 38 years construction financing. For full disclosure, I've done it mostly from the lender side, but I've also done it from the borrower side. So now we have the approvals and we need to pay to build this project. So what are we going to do? We're looking for a construction loan. So what is a construction loan and why is it different than a permanent loan? It's basically much more short-term financing, 2 years, a year. And I have to understand that the construction loan is going to present challenges to the lender. They are lending on a project that is not yet built and stabilized. The construction lender, as the developer, you are looking to the future in reliance on what approvals, the permits, the plans, the borrower's reputation, the contractor, the architect, and of major significance, the status of the market when the project is ultimately completed and ready for occupancy. Because of the uncertainty, construction lenders are going to rely much more on the credit of the borrower, and you're always basically going to see in a construction loan a full guarantee. I cannot in all my years of practice ever seen a bad boy or a carve-out guarantee. And they're generally going to require a much more higher equity in the project than a permanent financing transaction. Remember, the construction lender is concerned not only with the loan, but also are they going to have this loan taken out at the end of the project? And from the borrower's perspective, you need to be concerned with this too. So we have a couple of different scenarios that we normally see. One, the construction lender in their commitment for the construction loan agrees to be the permanent lender upon satisfaction of a number of conditions. Or you may have a third party who gives what's called a forward-looking commitment. Again, based on certain conditions, they agreed to take out the loan. The third option I've seen is what's called basically a standby commitment or a bridge loan. Here, the construction lender says, I will give you the loan, but it's for a short term at a much higher rate. It'll give you time to stabilize your project and to go out and get a permanent loan. You may have a project that contemplates where it's not going to be taken out, but it's going to be based on sales, tract housing, condos. Here, what normally we're going to see is the construction. There'll be an initial advance to start the construction, but it's often going to be based on how many contracts do I have? When the lender is not going to keep funding if you're supposed to be building 50 houses and you've only got contracts for 3. So what does the borrower really need to demonstrate at the outset? One word, the project is viable. That's a few words. The project has to, that's what they are looking for. The lender wants to know this project can work. The lender needs to know you've done all your studies. Your utilities are available, water, sewer, environmental, permitting. Do you have a redevelopment plan? Are you in a redevelopment zone? Are you applying for, or do you have a pilot in place? But the issuance of that commitment really is just the beginning. And it's really, once you have that commitment, now, if you are the lender's counsel, you've got substantial review of the permits and documenting. If you're the borrower's counsel, you're providing all this information to the lender. So what I have coming forward here is a number of slides, which is really the checklist that if you're a lender's counsel, you're going to send out. If you're a borrower's counsel, you're going to receive. I didn't put the standard note mortgage on this list. Those are on every single loan. This is just for the loan, construction loan. So what's your first is your construction loan agreement. Your construction loan agreement, I call the Bible, basically. It tells you how, when, what, where each advance is going to be issued or not issued. And that is from a borrower's perspective. If you read no document in your loan documentation, read the construction loan agreement. Other documents that are unique to construction lending, an assignment of your architects, your construction, your engineers, your plans and specs. The lender is going to want to be able to step into the shoes of the borrower in the event the construction project goes into default. That's what these documents do. You also, if you're in a redevelopment project and there is a redevelopment agreement, the lender is going to want to be able to take an assignment of the redevelopment agreement. They're going to want to give notice to the municipality that they are the lender. Same thing for the financial agreement if there's a pilot in place. And you're going to want to, the lender's going to want to have an estoppel certificate where the redevelopment agency is going to say, or the pilot who's running the pilot's going to say, everything is on the up and up. There's no default. This from the borrower's side, you want to make life easier for yourself. Negotiate right into these documents at the outset, the mortgagee protections, instead of having to go back and negotiate them in. Next thing we're going to look at is title. Obviously, we're going to get a title policy. From a lender's perspective, we do not want what's called a 3-year construction loan policy. From a borrower's perspective, I always want a 3-year loan construction policy. They're 1/8 the price of a full policy. Why do I not want one from a lender's perspective? Because if the loan goes south and the 3 years are up and I haven't foreclosed yet, I now have no title insurance. Every construction loan is going to have a pending disbursement clause, because remember, you are not, as the title, you're not issuing all the money at once. So each time a draw comes out, you go back to the title company, they do a rundown to make sure nothing has come up, no mechanics liens, no judgments. They will then insure the policy for the additional advance. Insurance, what is different? You're going to get builder's risk in addition to the general liability. You want to make sure your general contractors have insurance. From the organizational documents, if you are doing a redevelopment project with a pilot, your certificate of formation must have the language that is required in NJSA 40A20. That's the long-term tax exemption. You must have that language in there, and you must have a DCA letter agreeing that that language is in there, or you will not be able to proceed with the long-term tax exemption. Other construction documents that the bank wants to look at, and you're going to want, the lender's counsel is going to, the plans and specs, the project schedule, again, the architects, the engineer's contract, the general contract, subcontracts. We're going to want to look at all these. We're going to want to make sure there's letters from utility companies. We want to make sure that the property can have adequate sewer and water. Very important for sewer. I go back years ago, and I remember when you could ultimately build, but you couldn't connect into the sewage treatment plant because they didn't have capacity. Other things we want to look at quickly: are they in the wetlands, flood hazard, treatment works, sewer capacity, water connection? These are all permits that the lender's counsel is going to look at. They're going to look at the site plan approval. Has it been issued, and have the appeal periods expired? Because we don't want to lend, and you don't want to do your project until the appeal periods have expired. And I'm being told I have a minute left to talk, so I'm going to talk really fast. Other things you want to look at, county soil district. Are you on a county road? Do you affect the county drainage? These are all permits that the lender's counsel is going to look at. You want to look at tenancy documents, signed contracts, and lastly, for the first advance, there's going to be written requisitions that are going to have to be submitted to the bank, an owner's affidavit, and a title rundown. And that is the very abridged version of construction financing. And we're now going to turn it to Rob, who's going to talk about the actual construction documents.
Well, the first thing you have to do, first of all, I'm Rob Nussbaum. I'm a litigation attorney at Saiber. I've been practicing for 35 years. I've done a lot of construction defect litigation, breach of warranty litigation, personal injuries arising from construction sites. During the pandemic, I found myself drafting a lot of contracts of construction because building wasn't happening and developers were planning projects for after the pandemic. So I did a lot of construction drafting and reviewing of agreements, and that got us through the pandemic. But one of the key things that we use during that period is the AIA contract documents, and you can see them all at the website I have on the slide, aia.org. The AIA is the American Institute of Architects, and their webpage has so much information, but the key thing that I always focus on are the contract documents, and what they have are a series of six types of construction documents. You can do a seminar in any one of those six. The main ones that I use are the Series A, which are the contracts between the owner and the construction company, the general contractor. Series B is the contracts between the owner and the architect. And then Series G, which was mentioned in one of Randy's slides, are the documents relating to contract administration and project management forms. Sample agreements of, and there's a multitude of them. You can look at samples of the various AIA agreements on the website. All you have to do, they used to make it easier. Now you have to register and give your name, email address, and your company, and they'll give you free access to see what they have. But if you're going to use an actual AIA agreement, you're going to be required to purchase it. And the fees are pretty reasonable depending on what the document is. But if you don't use the purchase value, you're going to have a document that has the word draft and a big watermark on every single page. And you're running the risk of a copyright violation too, if you use those agreements without paying for them. In addition to the Series A, Series B, specifically, I always focus on the A201, which is the 2017 edition, which is the general conditions of the contract. AIA agreements are really good. They've been tested in litigation. They're used often. You're not required to use every single provision in it. You can tailor an AIA document to meet your own needs, because if you purchase the agreement, it comes in an editable form and it will track your changes until you accept all the changes and then have a document ready for signature. But if you're not inclined to use an AIA agreement, you can agree informally or formally with your owner, developer, et cetera, by coming up with your own contract. And that requires you to use the essential terms, which would be the names and addresses of the parties, the owner, the architect, the developer, engineers. You want to put in a list of all of the contract documents and drawings, a description of the work. You want to have the date of commencement as well as the date of completion or substantial completion. Importantly, you want to have the contract sum and any payment schedule, termination provisions, dispute resolutions, which I'm going to talk about shortly, and insurance company requirements, which I recommend having your broker involved in. The next topic, which is also something that can be the subject of a full seminar, is construction liens in New Jersey. The purpose of a construction lien is to protect the rights of a contractor, subcontractor, or supplier of materials who has not been paid for the services or materials they've provided in connection with the development of the owner's property. The statute NJSA 2A44A-1 has specific requirements that you must read, be familiar with, and follow. For a commercial project, you're required to file your construction lien claim within 90 days following the date of last services, material, or equipment that payment is claimed for. In a residential situation, you have 60 days to do it. And in that 60 days, you're also required to file what's called a notice of unpaid balance, which is an arbitration provision that requires the American Arbitration Association to determine whether or not you're entitled to file your construction lien. So that's a process and it eats up time. So you really have to pay attention to these deadlines because timing is important. They are a line in the sand. Courts cannot and will not extend these time limits. Don't overstate the lien claim. If you overstate your lien claim or file one that's beyond the time limits, you can be sanctioned for filing such a claim. And sanctions can include the attorney's fees and costs that the other side pays to get your construction lien discharged because it was improvidently filed. Liens have to be filed. The claim to enforce the lien, rather, has to be filed within 1 year of when you last provided those work or services, or within 30 days if the owner gets served with a lien claim and says, you know what, I don't want to wait a year. I want you to file it. You have to file the claim to enforce your lien within 30 days. Read the statute and follow the strict compliance rules because they can be costly if you don't. I mentioned alternative dispute limit resolution. Why do you want to use ADR and not litigation? Several reasons. It's less expensive. It's less time consuming. You get to choose your own arbitrator or mediator as opposed to having the court appoint a judge. Litigation is very time consuming, very expensive. You don't want to wait 3 years to get to trial if you can't settle the case while your construction project is pending. ADR is also private, so there's no public record of what the parties do. It gives the parties greater control over the process. There are several, sorry about that, there are several methods to consider for arbitration. First of all, you want to hire a mediator or an arbitrator. I prefer to use a retired judge. They have experience trying and resolving cases, settling cases. There are organizations like the American Arbitration Association and JAMS, which will provide you with arbitrators or mediators. They're very expensive. They're very good. They have a lot of experience, but I find it better from my perspective and my clients' perspectives to hire somebody that both sides can agree to. You set your own rules and you can basically control the time and expenses. Mediation is where a neutral third party tries to negotiate a settlement. Think of like the Secretary of State trying to broker a peace treaty between two warring countries. It's an effective way of trying to get a settlement or a resolution. It's not binding. Arbitration, though, can be binding or not binding. I prefer binding arbitration. You have a neutral finder of fact, again, preferably a retired judge, who hears the evidence, hears testimony, looks at documents, and then renders an award. It's presented in an informal conference room as opposed to in a courthouse, but it is under oath. And because it's binding, there are only limited times where you can appeal the binding determination by an arbitrator. And also there's negotiation. Parties can always try to negotiate a resolution of their disputes on their own, as long as they can agree to either something that they like or that they can all live with. Finally, and briefly, retainage. What is retainage? Retainage is the withholding of a certain percentage of the final payment for a set period of time, so it ensures that the contractor or subcontractor completes the construction project satisfactorily, correctly, and timely. It creates a financial incentive in the contractor or subcontractor that the project will be completed correctly. It's important, if you're going to have retainage, to have it set in the contract. If there's no provision in the contract that provides for retainage, there's not going to be retainage. It essentially provides funds at the end of the project to complete a project if a subcontractor or contractor walks off the job. If you retain a percentage of what they've been paid as you go, you have that pool of money. What percentage should be retained? That's typically 5 or 10%, but parties can negotiate for higher amounts. Good luck with that. And I've had contracts where they have zero retainage, but the rate needs to be specified in the contract for it to be enforceable. There's also statutes in New Jersey that limit the amount of retainage on state and municipal construction contracts and on Board of Ed contracts. So if you're doing a public work contract like that, you should look at those statutes to see what the limits are on retainage. Could be 2%, it could go up to 3% or 4%. And on Board of Ed contracts, it's limited to 5%. So that's retainage, construction liens, ADR, and contract agreements in a nutshell.
Can I just make one very 2-second cut with respect to retainage? From the lender's side of it, make sure your retainage in your contract matches what your commitment letter is requiring, because if your lender is going to require a 10% retainage in your construction contract of 5%, you've got an issue.
Okay. With that, I think Bob is going to take over.
Bob?
You're muted.
You're on mute, Bob.
Bob's muted. How do we tell him he's muted?
Okay. All good?
We're good.
All right. So I'm Bob Barone, I'm with Partner, and I've been doing this about 38 years. And I'm going to build off what the attorneys have mentioned. An architect by training, and we're an architectural engineering firm that focuses on the due diligence business. And so we bring a very different approach to the architectural engineering business and bring it to the lender and investor community. So building off what our lawyers have said, I'm going to explain a little bit more about how we help them, help the lenders, help the investors get a little deeper into the projects. And, so we were talking about construction financing, and we all know, as you've heard, it's probably one of the most riskiest forms of lending because you're projecting ahead. As Randi was saying, you don't know, it's not there already. So there's a lot of work and a lot of information that has to be analyzed and reviewed to make sure that our client, who may be the lender or investor, makes the right decision. And there's multiple risks. There's budget risk, there's completion risk, there's your takeout failures, document compliance that are very important to, number one, understand in the beginning and then monitor during the process. So, given that it's a highly risky form of lending, you really have to mitigate that risk and with proper underwriting and highly diligent loan administration, which basically incorporates everything that's been said so far. Those risks are mitigated through your attorney, your appraiser, a construction consultant, which is what we're talking about, which I'm talking about right now, your environmental consultant, and an insurance consultant. They all play a very important role in the lender or investor making a decision to move into a construction project. And what are we doing? What is a firm like ours going to do to help our client? And really, we want to make sure that the developer has built their project on paper before they get started. There's too many unknowns. If the project cannot be portrayed on paper in a satisfactory manner, there's concerns that it's actually going to get done right during the process. So our role really consists of two phases. We've got the pre-construction or pre-closing phase, and then we move in the construction phase. And what does a consultant like us do? We review all the basic construction documents. I'm going to go through those quickly. So our responsibilities move across the entire facet of drawings, contracts, budgets, permits, schedules, and we go through that. And how do we help? First, we have to understand the drawings. And very important as a lender or investor or even an owner to understand the status of your drawings. Are they schematic? Are they design development? Are they construction document? The AIA, has used for years and this progression of drawing development. And if your architect tells you, they progress. I do want to say that contracts generally should always be made on the construction document level, which is the most progressed. You may hear percentages thrown around, like 50% CDs, 70% CDs, 100% CDs. Or if you hear that you have a contract based on 100% DDs or design development, that's not a good thing. They're not developed enough to be completely enforceable, and you open yourself up to change orders, which is, of course, a bad term on a construction project. So, it's important to understand the level of documents and make sure that your construction contract is based upon a high percentage completion of your construction documents, which minimizes the chance of unknowns and disputes as to how certain things are going to get done. As a lender, for representing a lender, we want to make sure that the drawings that we're looking at are the same that the contractor is using for their contract. Many times you have different parties because drawings can be very complicated and they're issued in multiple sets with varying degrees of completion. It's very important to understand that that everybody's working on the same set of drawings and that everybody's going to agree. They need to be coordinated to mitigate change orders. They need to meet general compliance of for commonly accepted practices because of course architects get a little creative at times, and we want to make sure that the details and the concept of what they're trying to portray in those documents can be executed in the field, and keeps costs under control, and it also makes it again, change orders. And the other important thing with drawing specifications, especially if you have an end user, or you have to make sure that they're accepted. You have to make sure that everybody understands, as Randy was mentioning, that the takeout, that if there's an end user that has to come into play, you want to make sure that they're agreeing to the drawings, specifically the ones that the contractor is building to. So you've got these parties that have to come together, and that's part of the job that we play in the project. We look at the developer's team. There's much to this. So you want to go through that. You want to make sure they have experience with the product. You want to make sure the designers have experience. You want to make sure that the developer has specific in-house talent to manage a contractor and the architect at times, because it can be difficult especially on medium and large size projects, very complicated. So you want to make sure that their teams are sufficient enough to manage the contractor and protect the owner's interest, which of course protects the owner, the lender, and investors' interest also. We want to make sure the contractor and the architect are qualified for the project. We want to make sure that they have good paperwork management, and we want to make sure we have a general understanding of how it's going to be, built, whether it's union, non-union. This helped with harmony on the project, and there may be other requirements, specifically union level requirements for parts of the financing and parts of the investment that have to be met. So it's very important to understand that. We look at agreements. It was mentioned earlier about using Aia agreements, and that's very important. It's a good baseline, but there are multiple types of agreements, and it's very important for the owner or the lender to understand what type of agreements are being used and the risks related to each one of them. We have lump sum agreements, which are non-transparent and rely the contractor at the greatest risk. There's not much transparency, and you need to make sure that you have a strong contractor with a lump sum contract and completed documents. You have a construction manager as agent, where they're basically a representative of the owner, work on their behalf. The owner takes more risk on that in that process, because there is no contractor that's taking the risk. They're utilizing subcontractors. The owner's basically taking the risk on that. And then you move into a GMP, which a lot of people hear, guaranteed maximum price contract, which is really a blend of lump sum and construction manager as agent, where you have transparency, you have a lot of information provided to the parties, but you have a contractor giving a maximum price that they will construct the project for. So it's very important. And again, as like the others said, you can do a whole seminar just on types of contracts, but it's important to understand that there are different types of contracts. They have different risks, different rewards that you need to understand as an owner, lender, or an investor. We collect the subcontracts, we make sure that they match, we make sure they're in budget, we look at bonding. Bonding is basically a guarantee of a third party that the bonded contractor will perform. And again, this is still another complicated area, but bonding is very important to understand whether your contractor is going to provide it, whether it's required by your lender or by your investor, or even by a municipality that may be requiring bonds from that contractor. We get into SDI, which is another form of assurances that subcontracts will be met. You look at design agreements, making sure that's in place and make sure they're enforceable. Liability insurance, you look at labor agreements, municipal agreements. We do help with the building loan agreements. Lease agreements are very important, especially, again, as a third-party user. You have to understand if there's a lease in place, you need to make sure that the drawings meet the lease, the timing meets the lease, and that's all flows between the drawings, the contract, and the lease. in order to confirm that the tenant is going to take possession at the end. And again, if you have a takeout lender or an end user agreement, that's another area where everything has to align, that you want to make sure that occurs. We go through permits and approvals. Again, do they have their zoning and planning approvals? Utilities, very important, as Randy was mentioning. You want to make sure that the utilities are there. And additionally, you need to understand the costs of these utilities. If you're building a property that might have some type of extension, a water main extension, a sewer main extension, there can be significant costs in bringing your utilities to the site. So it's very important to understand that as you're closing a loan, understanding what the conditions to getting that water main there and what the cost might be, so that you put in the budget. You look at your building department approvals. We look at, it can be broken up, into sheeting and shoring, foundation, building. But in any case, the lender or the investor or even the owner has to make understand the progression, when they're going to be obtained and how they're going to flow, and make sure that, if you're a lender or investor, you have to make sure you agree on what stage you're going to come in. Are you going to require a foundation permit? Are you going to require a full building permit before you close or before you do your initial funding? So there are progression, and it's important to understand. You want to look at historical commission approvals when you're doing a rehab. Even if you're not, there's some areas that you may be in a historical zone that you have to meet. And you also want to make sure you have your offsite work approvals, which is very important. Schedules are important. Your project schedule, your contractor schedule, cash disbursement schedules are important to get from your contractor to make sure that you understand the flow of the project and you can track that. We look at, you have to get your hands on your surveys, your geotech reports, accessibility for existing buildings, environmental reports, understand if they have to meet LEED or WELL or one of those requirements as a condition of their building permit or condition of their approvals. There are some municipalities that require that. So as a lender or investor, or even an owner, you have to understand all this has to be in place. And then we look at budgets. And the budget is the contractor's budget, the owner's budget. We make sure we understand where the actual awards of the trade agreements are, and then are they using bonding or SDI? We have to make sure we understand the risks, what's known and unknown as a client gets towards a closing, and then you make recommendations. Contingency budgets are always the biggest question, is what they should have. The owner, probably ground up, maybe 3 to 5%, renovation, maybe 8 to 12%, nowadays, and that's completely contingent upon the quality of the documents, where they are in the process. The less certainty you have, the higher the contingency budget. Contractors sometimes have contingencies also. You don't have them in a lump sum as much. Cost plus you may. In a GMP, you might have 2 or 3%. So, expect to see this in there. And then, of course, we put a report together that is issued to our client. There's a lot to go through, and we do work with the attorneys along the way to conform construction agreements and design agreements and schedules to make sure that our work is consistent with what's being put in the loan agreement, and that we all work together for the common goal of protecting our client. Then during construction, we follow it. We monitor the progression of the work, periodic site visits, going to see the status of the trades, identifying problems, document the project. Quality control is very important. We go through the payment requisitions. We talk about, what's done, where's the actual backup. Very important that procedures are followed, not only with the contractual procedures of how to administer these payments, but also with the loan agreement and what the lender has agreed to. That means there may be stored material and deposit requirements. There's procedures for change order acceptance, partial and final lien waivers to protect us from potential liens that was spoken about earlier. So part of the process is during the application of the payment and the whole funding process, lien waivers are obtained to make sure that we're not at risk for liens on the project. We look for designer acceptance, and we do track retainage. And getting back to retainage has been getting more lenient over the years. It used to be 10% across the board. Now it's 10 to 5. It might be less, depending again. We cross states, so different states have different requirements. It's very important to understand those requirements. We go through, the pay applications and make sure that everything ties out. We're making sure we understand what change orders are approved this month, getting copies of those change orders, make sure they're appropriate, make sure they're fitting the budget. We go through the backup of a schedule of values, which your contractor should submit, along with all these subcontractor applications, depending on the type of the contract. And you want to make sure that you're understanding, are the percentages okay? Are they asking for store materials? Are there general conditions and general requirements being spent ahead of the work? And is the contractor fee being made? Are there line items that have spent over? You have to watch this. Getting the architect's signature, very important, because we want to make sure the architect is on board, that the work is, conforms to the documents. Go through cost control, change order logs, cost reports, review of shop drawings, review of contingency budgets, line item allocations. A lot to go through. Control testing, schedule conformance. Are they tracking along to schedule? Are they spending the money as they're supposed to be spending? And are they going to meet their completion dates? Very important to look at. So we've got at the end the completion acceptance, full waivers of lien, designer acceptance, contractor acceptance. Very important for end user acceptance. If you have a bona fide end user, look for certificate of occupancies, your as-built, warranties, consents, and eventually you're going to make a release of final payment retainage, which has to be done in accordance with the contract and the loan agreement. So a lot to talk about, a lot to go through, but it's a consistent amount of work, goes through the entire process of the life cycle of a project, and that's what lenders and investors should be looking for, and that's where we are.
Wow, a lot of information in a very short period of time. Thank you very much, speakers. This is our opportunity now to field questions from our audience. And while our attendees are thinking of what questions to ask, I've written down 2. So let me throw my first 2 questions out to our speakers. My first question is for Justin. You talked about zoning and permitting. New Jersey as a whole is famous for having takes a long time to get a project approved. Can you speak to just that general fact? Are things getting better in New Jersey? Are they getting worse? What's your thoughts when you speak to these developers who obviously are critical, have a critical interest in this? What's going on in the state of New Jersey today?
So I guess my answer to that, Ron, is it feels like every year it actually gets a little bit harder. There's a lot of changes, and I think municipalities are taking a harder look at things like storm sewer capacity. They want to offset as much impact lately that a development has as they can. So it's a 2-pronged way of looking at it, right? I mean, one is, they are trying to mitigate impacts, and the review takes a little bit longer, and they ask for more things lately. There's also the instances where they're trying to do the right thing, but it really gets bogged down that you try and push back on. For example, we just represented a developer who put up a nursing home, and the town really wanted us to put up bike racks for bicycle parking, and they wanted plan details on all that. There may be employees that bike to work, but a nursing home is probably not going to be the kind of site that generates the most amount of bicycle traffic. So it's a mix. It's legitimate concerns that a developer may work with, and then it's are they being a little too fastidious when trying to make sure all the site plan details are checked. But no, I mean it's getting more detailed and more involved. It feels like every year it's taking a little bit longer.
Thank you, Justin. My second and last question will be for Bob. Bob has presented a lot of detail, a lot of work, and I'm just curious, Bob, in your 30 some odd years of experience, is it the lender, is it the borrower, or is it a third party that typically hires your firm to do many of the tasks that you've outlined in your presentation?
Our firm is retained by the lender
By the lender.
99% of the time.
Okay.
We're there to protect their interests. It could be a lender or it can be an investor in a project, but we're there on their behalf to protect them.
And I'm sure you've been called on to evaluate a project once it's supposedly all completed, and obviously there are issues that go wrong. Can maybe just share one or two of your experience with the audience? What happens when you get into a project and you find out things didn't go according to plan?
Well, frankly, I mean, that's been the last 2 years, right? So, nothing has gone as planned over the last couple of years, and you really have to evaluate the issues. We've had subcontractor failures or delays, and it's really working to understand how the team is going to solve that problem. It's asking the right questions. Lately, we've had, over the last 2 years, one of the biggest issues we've had is the cost escalations, which certain owners are taking a very hard position on and not helping the contractor. And some owners understand that they're unique times and there's a sharing of it. So depending on that, we've seen significant issues related to cost escalations. And we're starting to see subcontractor failures and even general contractor failures because of that. So the important thing is understanding the ability from the developers and to the contractors team to solve the problems and how to handle this diversity. But of late, we've seen we're starting to see more subcontractor failures, and we may see more because they're reaching the end of their ability to carry these projects. And manpower is remaining a problem. Things are loosening up on the escalation, but manpower is going to continue to be a problem. So we're seeing a lot of that, and the solution is usually longer schedules and some extra costs.
All right, we got our first, thank you, Bob. We got our first question from our audience. It's from one of our banks, and either one of our speakers can handle it. With respect to retainage, what is the acceptable time to release the retainage?
In my experience from the litigation point of view and construction contracts, it's when you're satisfied and ready to have final payment issued. You're not going to issue final payment if there's significant issues, you haven't got a CO, there's plaster cracking, there's problems with the fit outs. You're going to want to hold that retainage as long as you can until you're satisfied that you're getting the product that you paid for. And that usually comes with the issuance of the final payment.
Yeah, most loan agreements, at least most of my construction loan agreements, say upon issuance of the final CO, sometimes temporary CO, if we're talking about the only thing that they can't do is maybe asphalt because it's the winter. If you've got a redevelopment project, it's normally going to say the certificate of completion, which is issued by the redevelopment agency. And one issue on retainage, and Bob, I was going to actually ask you this question. I have begun to see requests instead of retainage at the end of the project, where it's line item retainage, and at the end of the task, the borrower is asking for the release of the retainage. I always think that's somewhat dangerous, but I've seen banks agree to it.
Well, a lot depends on the type of agreement it is. I mean, if you're doing a lump sum agreement, I agree with you. I'm a big fan of holding retainage throughout, because you just don't have the transparency of what's happening inside the contract and who's been paid what and what the risks are. But if you're doing a cost plus or a GMP form of agreement and you're seeing actual costs, we're seeing that the trend has been over the last 5 or 7 years is to reduce retainage from 10% to 5% on a line item basis when you have actual transparency, and to do early releases for early trades. They may not hold the foundation contractor till the very end. They may reduce them or release them once they've completed a task of work. So most clients are accepting that. It's been the trend, but it depends on the type of contract that's utilized.
Thank you.
All right, I'm still waiting for some additional questions from the audience. At the moment, I don't see any, so I'm going to fill in. Lee, do you see any other questions from the audience? I don't see any other questions, so let me end up with one last question for the attorneys. The attorneys kind of just mentioned fairly quickly the whole issue of foreclosing when a project isn't done correctly or properly on time. My comment is the other side, the borrowers pretty much know in this day and age that lenders' last remedy, the last thing a lender wants to do is take over a project. Does that give the borrowers kind of a leg up in terms of any negotiation or any issues in terms of trying to get to a happy medium with respect to a settlement?
Well, I've negotiated distressed projects. I wouldn't say it's a leg up, because the flip side of it is, as I think I said, you generally have you 99.99% have in construction contracts full guarantees. And if those guarantees are worth something, then that levels the playing field a little bit. If the guarantee is not worth it, then yeah, there is a leg up to some extent to the borrower. But I do agree with you. The lenders do not want to step into the shoes of the borrower, especially when you're dealing with construction, and especially when you're dealing with like a redevelopment type of project, because then you are stepping into a lot of rules and regulations. They generally try to work it out. They may try to sell the project in the piece, before they go to foreclosure with obviously the agreement of the borrower. Stepping into a construction half built comes many challenges, and that's the uncertainty on a construction loan. That's why you also want the assignment of the engineers and all those contracts and the permits, because if you do have to step in, you need to hit the ground running and be able to utilize those specialties to start up the construction again, or to be able to transfer it. But so it's a balancing act, and part of it is how much equity is the borrower going to lose? What skin in the game does the borrower have?
Okay, thank you, Randy, for that explanation. I want to thank our speakers for a compact introduction into this particular topic. I know, as each one of our speakers mentioned, you can speak a half a day at a minimum on these various topics. We only have a short period of time. And to our audience, I want to just invite the audience at some point after today's presentation, if you have any feedback with respect to anything that was mentioned or any ideas with respect to future webinars. Let me just check the chat or the Q&A one more time. I know some of the audience members are asking for a copy of the presentation. We'll handle that after today's presentation. That is not a problem. But certainly if our audience has any suggestions for future topics, you can send them to me. You can send them to Leah at the Mid-Atlantic Real Estate Journal. We will handle that. And again, I want to thank the speakers for their time, for their participation in today's presentation, as well as their sponsorship. And with that, I also want to thank Mid-Atlantic Real Estate Journal for putting this all together and being the backbone of our presentation. I'm going to check the chat one last time just to make sure I did not miss anything. And I think we've got everything covered. All right, there is one more question that just came up. So we got a moment. And the question is, does the Lenders Council at the review of the contract between the ownership and the GC, do they provide feedback to the lender as part of their review?
I generally look at the contract, not so much for, I mean, I tell the lender what the contract says, but what I'm looking for is does it match the retainage? Does it have any specific rights where the contractor can get out that's outside of the norm? Does it match the budget? So I'm looking more, I will give the lender that information. I'm not looking for the nitty-gritty portion of the contract. I'm looking to make sure it meets what we understand in our, it meets the project budget, it meets the retainage that we've agreed to. The contractor doesn't have, and that's a biggie, doesn't have some type of right to leave or walk or increase their fees that's outside the norm. Those are really what I'm looking for. And that it has the right project in there, and that it says it's going to build the whole project. I've actually seen them where the project is incorrect. That's a big.
That's a big problem. Bob, any last comments from you?
We look at the same things. We go a little deeper because we're comparing not just that it goes with the budget, but we look at the qualifications, the assumptions, make sure, there's not too many allowances. We look at the construction agreement to make sure it really conforms to budget and it brings additional risk to the owner. So it's similar to what Randi does, just a little bit more focused on what's in the drawings and what clarifications they've come up and how they've gotten through their price to make sure that the project is not hasn't been changed or there aren't any undue risks that affect the budget or the schedule.
I just thought of one last thing for Bob. I know you said in your presentation you review the background and the bios of all the different players. Have you ever had a situation where you looked at the developer's background and you felt that the developer didn't have the experience and the wherewithal to do the project?
We have, and that's where we talk about whether they've got the right team. But ultimately, it's up to our client. And frankly, sometimes their financial wherewithal or relationships. We've never had a deal not go forward because we didn't think the developer had the right team on it because somehow it made sense to our client.
Got it. Understood. Okay. That pretty much completes our webinar. Again, want to thank all our speakers. I want to thank both firms for being available and participating in today's program. If any of our audience members has any remaining questions, you can certainly email them to me or Leah, and we'll get those questions forwarded to the prospective speaker, and we'll get you an answer. With that, I want to thank everybody for their participation. I want to thank the Mid-Atlantic Real Estate Journal. That completes our webinar, and that's it. Thank you, everybody.
Everybody.
Thank you.
Have a good one.
Thank you. Bye-bye.